Good morning, everyone, and welcome back on today's episode of the Conference of Future of Europe. Today, we have the chance to receive our guest, Morgane Denieul, a student in International and European Law Master at the Catholic University of Lille. The topic of today will focus on the system of mass surveillance in Europe and how balance should be made between national security and right to privacy. So, can you please, Morgane, tell us more about it?
Good morning. Thank you for having me. The balance between national security and the right to privacy is still ongoing since decades now, both with the European Court of Human Rights and the Court of Justice of the European Union. The mass surveillance programs can be seen as a violation of citizens' private life, even though it appeared necessary to protect national security. In the light of the proliferation of the threat to national security, such as terrorism or serious crimes, a high margin of appreciation from the states is deciding how to better protect the security of their citizens. The operation of bulk interception regime does not in totality violate the convention, but only Article 8 of the convention as it is necessary. Nevertheless, this regime pursuing a legitimate aim shall provide adequate and effective safeguards to the right for privacy. Besides, EU law may be regarded only as complementary in assessing the legality of the activities of states in respect of non-targeted surveillance programs. However, the restriction is not to be found in the European Convention of Human Rights, which stipulating the protection of individual rights does not therefore any exception to its application in the field of national security. The Convention could therefore be the basis of obtaining international protection against unauthorized state interference, also in the case of bulk interception programs.
In your paper, you have taken the example of a Sweden case, right? Can you tell us more about how this case could have influenced this topic?
Well, the 25th of May 2021, the European Court of Human Rights has rendered a case called Centrum for What Visa versus Sweden concerning the bulk interception of electronic signal in Sweden for foreign surveillance purposes. Another important case named Big Brother Watch versus UK has been rendered by the same court the same day, setting an important precedent on the safeguard necessary to protect the right to privacy on this matter. In 2018, a first judgment was rendered concerning this same Swedish case, and the court has found that the signal intelligence regime in Sweden was in compliance with Article 8 of the Convention. This previous judgment has found no violation of the right to privacy, underlying the idea of a divergence between the CJEU and the European Court of Human Rights. However, as opposed to this 2018 judgment, this time in 2021, the court has held that the mass surveillance program has violated Article 8 of the Convention because the Swedish regime did not contain enough end-to-end safeguards in order to provide adequate and effective guarantee against arbitrariness and the risk of abuse. This Swedish regime constitutes a violation based on 3 points, which are, firstly, the absence of a clear rule on destroying intercepted materials. Then there is no rule imposing that when making a decision to transmit intelligence material to foreign partners, consideration is given to the privacy interests of individuals. And finally, there is a lack of a posteriori effective review. Consequently, this system potentially affects all users of communication which have their communication intercepted and not only a group of persons targeted. The availability of remedies is not sufficient even though the court does not question the necessity criteria of this system. States cannot escape basic guarantee related to the proportionality principle.
You said that the 2018 judgment highlighted a divergence between the Court of Justice of the European Union and the European Court of Human Rights. But what is the link between the Court of Human Rights and the Court of Justice of the European Union?
Well, it is true that the European Court of Human Rights is not strictly speaking a court of the EU. Nevertheless, the European Court of Human Rights was created to ensure the respect and freedom of the right and freedom granted by the European Convention of Human Rights. Case law developed by this court can have an important influence on EU law since the fundamental rights guaranteed by these conventions are also general principles of EU law. These two courts influence each other. The CGU has also rendered judgment on the basis of the book collection and processing of personal data, with, for instance, the digital right case or privacy international case. The CGU has applied a higher threshold of protection for individuals compared to the first Sweden case law. In fact, the CGU has held that the indiscriminate and very general nature of this system interfere with EU fundamental rights and requires adequate safeguards. It means that derogation and limitation in relation to the protection of personal data must apply and is so far strictly applicable. Consequently, when looking at the decision ruled by the Grand Chamber in 2021, it is to say that now the European Court of Human Rights follows the line that the CGU has taken since a few years now. Synonym of a will to change the settled case law and a need to improve it. This influence of the CGU is manifested by the change of position of this court in 2021.
But is there a will to harmonize the judgment of the European Court of Human Rights with those of the Court of European... with those of the Court of Justice of the European Union?
Yes, there is. With the Lisbon Treaty, the EU made a legal commitment to accede to the European Convention of Human Rights, which is now still under negotiation. Currently, the act of the EU institutions, body, and other agencies cannot be challenged before the European Court of Human Rights. Nonetheless, the main technical challenge is to achieve the accession in a way that respects both the fundamental characteristic of the Convention and also the fundamental characteristic of the EU. So this is part of the project of the future of Europe, since this step by subjecting all European institutions to the authority of the Convention would contribute to consolidating the protection of human rights in Europe in a way that will benefit complainants, as well as ensuring consistency in the decisions rendered by these two courts.
Many scholars argue that this Swedish judgment is an important win for privacy, only in appearance. What problems can be held regarding this decision taken by those courts?
The main criticism made after that decision is the normalization of this type of system, as Marko Milankovic, an author, has said. Indeed, the court considers this program necessary to the security of member states. The opinion of the judge Pinto is relevant in the Swedish case, since he is claiming that the Swedish legal framework of bulk interception is problematic, leading to a practice of this regime with not enough safeguards. According to him, there is a lack of forcibility because it does not delimit serious cross-border crimes sufficiently, and it raises more threats to civil rights and democratic governments than a targeted one. Furthermore, this mass surveillance system is still in force and has not really changed since the judgment, which supports that idea of a normalization of this type of system. Nevertheless, even if the judgment can be criticized, this is not the role of the courts to give an ideal model of the Swedish law and of the Swedish system, but rather to review the compliance with the Convention. Accordingly, it was not the aim to prohibit it, but rather to improve how it was regulated. In this way, even if the mass surveillance system is a touchy political subject under the state responsibility where the EU is just giving a hand, maybe the EU should have a bigger impact in order to provide enough safeguards for citizens. And Mark Kallenberg said, especially as it is now subject to more public debates.
Thank you, Morgane, for your presentation, and I hope everyone enjoyed it. See you soon on the next episode of Future of Europe.